where a nation has made a policy decision, not that they're going to say people didn't do things, but that it's better for their country to go through reconciliation. That doesn't mean that the prosecutor could not. What it means is the prosecutor has the discretion not to, for him to take an action to prosecute, would somehow not be in furtherance of justice. And so I think that when there are national solutions that look like they're working reasonably well, that look like they aren't really just a sham to let somebody at the top get off, the prosecutor will defer and say, let's let those things take place. The second thing is that if the Security Council is going through a process where they think they can bring peace to some place without there being a prosecution, there's a deferral system that when the Security Council by a majority vote says not to prosecute, it can defer for 12 months, which can be repeated however many times it takes. And so if the Security Council makes a decision that they don't want the prosecution to go forward ever, they could keep making those 12-month deferrals. So I don't think there's really a conflict. I think they can both be reconciled and go together.
Yeah.
When you guys were talking, you guys were referring to individual person who commits a crime. My question is, if it's a nation or it's a, more than just one individual, how does the ICC trial that nation? For example, the only example I can think of is Rwanda incident, where the United Nations took forever to take any action to send people in and to stop the genocide that was happening. For the ICC, I know it's there to prosecute, but how are they going to help to stop the situation? Like, how are they going to, what action are they going to take to intersect what's going on and stuff like that? And you guys are saying that they're independent of the United Nations. My curiosity is, how independently are they from the United Nations? Because I don't think that's possible for them to be extremely independent of each other.
Well, for example, the International Red Cross is independent of the United Nations. It's a separate organization. The International Criminal Court is a separate organization. It is independent of the United Nations. For criminal liability or responsibility, according to the International Criminal Court, it will only be for individuals. So you will look to the leaders to find the individuals who are the most culpable, the most responsible for the misconduct that's occurred. There won't be a nation being tried, and there won't be corporations or businesses. It will only have individuals who are being tried. So to hold a nation responsible is not something that the ICC will do. What they will say is, someone was acting really not in the interest of their nation, but instead doing something that's against international law, and as far as I'm concerned, to act against international law is very rarely, if ever, in the interest of any nation. And so we're going to hold those individuals who acted in that way responsible. I really think there's an interesting issue that deals with what the responsibilities are that come with sovereignty, and whether or not, if you're a sovereign who engages in this type of conduct, you no longer have the privileges of a waiver that come with sovereignty, that by engaging in this kind of conduct, you no longer have that waiver that would come with being a sovereign. And that's a privilege that other countries give sovereigns. But I think that with that goes the responsibility to take care of your people, and when you're actually acts interest, you may actually lose that privilege of not being prosecuted.
I would add a couple of things to that. I mean, you're on to the sort of key issue here, which is the whole point of the International Criminal Court and the development of international criminal law is to focus these crimes back onto individual human beings, right? The sort of historical way of thinking about conflict between states and nations is, Germany invaded Poland in 1939, and in a sense it was the German nation that carried out that attack, even though of course Hitler ordered it and he had his generals and staff that worked for him. And, so the part of the entire project is to realize that when nations or corporations or any other group sort of carries out a plan like this, that ultimately means that there's individual human beings doing these acts, right? And if these particular acts, murder, forced transference of civilian populations, torture of prisoners, right? We can agree as an international community that these are so abhorrent that they should never take place, right? and the individuals responsible should be held accountable. Now, you also are touching on to another difficult political aspect of this, which is, you know, if you have a commander, or a president, or a dictator, and his top, you know, advisors and military echelon that order it, and then they have an entire command structure of, you know, thousands or tens of thousands or hundreds of thousands of troops and personnel that are working for them, right? Who is it that you bring to the court in The Hague to hold accountable? And the language of the ICC statute is written in such a way as to make it clear that the focus is going to be on the people that are most responsible, or in effect the people with command authority. Now, it's possible to imagine a situation, right, where you know, somebody at the field level, a very low-level commander, or even a private, you know, might, you know, take a prisoner out and execute them point blank without any instruction from above, right? And in that case, that person should be held accountable, and probably no one above them, right? But in the cases that we're more interested in, you know, like the genocide in Rwanda, right? Even there, I mean, it was a very disorganized thing, right? There was no sort of command structure where the Hutus said, let's go out and kill the Tutsis. Instead, there was a radio message broadcast, right? To say, you know, Hutu brothers, go get your machete and, you know, slaughter your Tutsi neighbor. And then hundreds of thousands of people went out and did that, right? Well, in that case, you would focus on, you know, the owner of the radio station and the person who made the broadcast and, you know, the people who tried to get that message out as being, in a sense, the most culpable, right? And that's sort of a recognition that any court operates with limited resources, right? The LA prosecutor's office or the Orange County prosecutor's office can't possibly prosecute every crime that takes place in LA County or Orange County, right? They choose their battles and decide what's going to sort of do the most for justice to, you know, which individuals can we focus on that help establish the rule of law.
I have 4 different questions. First, you said that
Ask them one at a time.
earlier this year, the tribunal for the Khmer was set up, and you said the ICC is not trying that. So, which you know, international court?
For Cambodia?
Yeah, Cambodia.
For Cambodia, it's going to be a hybrid tribunal that hasn't yet really been established. The agreement between the Cambodian government and the United Nations was reached, I believe, October 4th. It was at the beginning of this month. Until there was that agreement, donor nations weren't willing to give money to set up the tribunal. And it's
The International Criminal Court at all.
Right, okay. The second question is, you mentioned that the ICC only steps in when the local or the court system of the states or the countries fail. So isn't that the case where if the United States has a credible, functioning, fair military court system, then why would they support the ICC if they have their own way of trying soldiers that commit, you know, crimes? As we see in Abu Ghraib.
The reason the United States should support the court is not because they're thinking U.S. military will be held accountable, but instead because they want a system in place so that there will be accountability in other countries when those court systems fail. And so the U.S. should support this because in a situation like Cambodia, if that were to happen today, there would now be a court system that could take care of it, that would say, your leaders, if you're going to go out and do these kinds of things, you can be held responsible. There's still a problem about enforcement because there's not really any enforcement power. It's voluntary. And so unless someone went in and got the leaders, you wouldn't have custody of them. But the thought that they might be prosecuted should be a deterrent.
But like I think, like always, the U.S. is going to protect their own soldiers before they worry about other criminals, right?
And they can do that in their own courts.
Okay, the third question is, the future of the ICC, how do you think it's going to last? I mean, with all due respect, but how is it going to last without some enforcement mechanisms and then some kind of connection to the UN? There's no enforcement right now, right?
Well, go ahead. I have an answer.
The ICC is dependent on states, ultimately, right? National governments to investigate crimes, to help to gather evidence, right? To secure evidence. If there's an actual conflict situation going on, right? I mean, it's very, the ICC prosecutor can't really send in, you know, his own investigative team to try to find out what's going on unless somebody can militarily secure the area, right? Now, I mean, there's sort of different scenarios that you can imagine, right? The civil war in Colombia today, or if you want to call it a civil war, guerrilla war, whatever it is, right? It may be the case that the Colombian state has an incentive to help capture the drug lords, or but they're unable to try them in their own court system, for example, because Colombian judges could be subject to assassination or kidnapping or having their families targeted if they try to try some of these people within Colombia, right? So in that case, you can actually imagine a lot of cooperation coming from the Colombian government to provide evidence to send these people to have them prosecuted in The Hague, where presumably the international justice legal system is somewhat more immune to the narco-trafficking, money and the reach of their power, right? There's other cases where, you're going to have out-and-out civil wars, or something like Yugoslavia, where until the conflict really comes to an end, it's going to be difficult for any kind of investigation to go forward, right? And the ICC will be dependent on intelligence from the major powers, like the United States, France, and countries that have satellites and that have extensive intelligence networks on the ground to collect evidence and find out what really happened, right? And that's actually another reason why it's important for the U.S. to join the ICC, is that it, in a sense, has more resources than other organizations. So you're right, there's this sort of need for cooperation, if you want, between a UN peacekeeping operation or UN enforcement operation and the ICC for them to succeed.
And I have another answer. Whoever it is who's alleged to have committed those crimes someplace else, and let's say that there's a Security Council referral and saying, yes, we want to try this person. Well, there's 97 countries where that person can't go. And if that person goes to one of those 97 countries, they have an obligation of cooperation to turn him or her over. And so that's one of the reasons that the more countries that are parties, the better it is, because there's going to be less places for these people to go where they can get away with it. And maybe they'll be stuck staying in their homes. That's fine. If they can't get out and there's no way to enforce it, so be it. It means that we won't be able to go in, but it limits the options for those people about what they want to do.
I mean, I support the ICC, and I think Bush is stupid for not continuing what they're doing. But my last question, the case of Sudan, are you going to do anything about that? Or?
The Sudan is not a state party to the treaty. And so the conduct that's occurring in the Sudan, the only way that that could be brought before the ICC is if there was a Security Council referral. That's one of the bad things about the U.S. being on the outside of this, because when the U.S. is on the outside of it, you will never get a Security Council referral. And so we certainly want to have all the 5 permanent members of the Security Council to be members. It's not that way right now. I have done quite a bit of research on the administration's reasons that they oppose the treaty, joining the treaty. I don't believe any of them are well-founded.
And the situation in Sudan and Darfur today is maybe not yet to the point where it's really appropriate for judicial action. I mean, clearly crimes have been committed, and hopefully someday someone will be in a position to prosecute them. But we're going to miss some things. Some conflicts are going to happen. Things happened before July 1st of 2002, right? The ICC has a limited budget, but I think it was 60 million euros the first year, and they've got 70 or 80 million euros next year. And unfortunately, there's enough war crimes and genocide in the world to go around. So it would be more interesting, I think, or in a sense more important, to see how well the ICC does in dealing with Uganda and Congo and the cases that it is able to deal with, rather than sort of worrying about the holes like Sudan and Iraq that are still out there, places where the ICC doesn't have jurisdiction. But hopefully, someday everybody.
Our question, the first part is how effective and valid would the ICC be in terms of legitimacy and jurisdiction in the international community if superpower nations such as the U.S. is not on board? And the second one, you did a comparison between Vietnam and the U.S., how they're both not on board with the ICC. So in that terms, if a big powerful nation like the U.S. who's not supporting ICC, why should we expect a lower third world country like Vietnam to be in support of it?
Put his map back on.
because it sort of shows, right, the amount of international support that there is for the treaty. And one interesting thing that you notice if you start to look at this map is that a lot of states that agreed to join the ICC are places that have seen conflicts of one sort or another in the last 10 or 20 years, you know, like a lot of West Africa, you know, right, or a lot of Central Africa, the Lake region, or all of Latin America, right, which experienced brutal dictatorships. And, you know, one of the motivations behind this is that they know that their own legal systems are not always that secure. They don't have the benefit of a legal system like we have in the United States that functions pretty well most of the time, right, that can hold their own political leaders responsible. So they see this as sort of a stopgap. If you have a president or, you know, a dictator, in fact, that is prepared to try to use the law or use the power of the state to avoid their own selves, you know, being brought to justice, then this international mechanism is sort of a way to protect themselves against that. So in those societies, the court has a great deal of legitimacy, I think, even without the U.S. being part of it, right? But clearly, it would have more legitimacy, you know, if the U.S. would agree to play by these rules too. Now, I mean, it's not all bad in the sense that the United States, you know, still subscribes to international law, we believe, for the most part. Now, some of the things that have happened under the current administration, right, leave us to wonder. But even under the Bush administration's, you know, Department of State, right, they make an effort day to day to justify their conduct in terms of international law. Right? They haven't rejected international law out of hand. Right? They claim they're in compliance with the Geneva Conventions in Cuba. Now, I think they're not, and I think we can argue that. But it at least it allows you to enter into a discourse with the administration and argue about them, right? If they accept the validity of the concept of international law.
I'm not really going to answer your question, but you've given me a segue. You talked about the lack of U.S. support and what that might mean to other places. Well, Mike talked briefly about the American Service, the so-called American Servicemen's Protection Act, Service Persons Protection Act. There's another amendment that was proposed this last summer called the Nethercutt Amendment. Mr. Nethercutt is, I think, a representative from the state of Washington, if I recall, and the American Servicemen Protection Act cut off military aid to countries that would not agree to Article 98 or bilateral immunity agreements with the United States. In other words, not to turn over U.S. citizens. And as an aside, those Article 98 agreements don't just say U.S. diplomats or U.S. military. They say U.S. citizens, so that if a soldier of fortune, a mercenary, is caught in those foreign countries, they have to be returned to the United States and not turned over to the ICC. But the Nethercutt Amendment takes it a step farther. The Nethercutt Amendment cuts off aid that's not of a military nature. It cuts off aid from a fund that's supposed to be going to increase cooperation on security and anti-terrorism efforts to countries that don't sign bilateral immunity agreements. Now, to me, that makes no sense. We were engaged in a campaign against terrorism, and we want everyone to support us, but we're going to cut off money to people who are willing to work with us if they won't agree to these bilateral immunity agreements. So, the short answer to your question is, yes, it would be a lot better if the U.S. was supporting this, but in fact, the U.S. is doing something against this. So, one of the things I would like from each of you, after you leave here, is to contact your congressman and say, what is this Nethercutt Amendment, and why are we punishing these people for doing the right thing?
It's unfortunate that Vietnam is, it's not part of the ICC, and if you guys can get them to be part of it, I mean, hands up for you guys. It's a two-part question. Human trafficking is a $7 billion business in the world today, and first of all, the first question is, of the three crimes, genocide, crime against humanity. Now, is human trafficking considered a crime against humanity? And if it's so, has the ICC done anything about it, or do they have plans to prosecute people around the world, not just in Vietnam, about the human trafficking issue?
You can do this. Crimes against humanity includes the crime of enforced prostitution. It includes the crime against humanity of sexual slavery. Similarly, there are war crimes. The war crime of sexual slavery and the war crime of enforced prostitution. Typically, for the human trafficking, it's those types of situations. And so both of those, if committed on a widespread basis or as part of a policy or procedure, would be considered crimes within the jurisdiction of the court.
Yeah, that's sort of the good news. The jury view, perhaps. The bad news is, right, to be a war crime, you have to have either an international armed conflict or a domestic armed conflict on a significant scale. So the things that you're talking about probably aren't going to fit into the definition of a war crime. On the definition of a crime against humanity, as he said, the key criteria there is that whatever the conduct is, and it lists, 20 or 30 things that can be a crime against humanity. One of them, a couple of them he just mentioned include, what's the exact terminology, but the idea of enforced prostitution, for example. The problem is it has to be carried out as part of a widespread plan of attack against the civilian population, okay? And so in the sort of historical development of this crime, what the authors of the international treaties had in mind is probably not the sort of situation that you're describing, right? But it's certainly conceivable that judges in the future could interpret that language to mean that, right? The threshold problem that some, smart prosecuting attorney will have to be making in The Hague to persuade the judges is that the networks that you're talking about, the $7 billion industry, is in effect part of a widespread systematic plan, to attack the civilians. That would be the threshold.
Let me add to that I think you may have noted too that during the negotiation in '98, there was effort by NGO to include a language to cover human trafficking. But unfortunately, one of the like common international politics, one of the compromise that we have to make is that how you handle and balance all the different interests. There were efforts to include drug trafficking as one of the major crimes because all the South American countries, that's what they want. They want drug trafficking as part of the ICC. So there had to be a lot of compromise that were made, and unfortunately, the language to cover the human trafficking, not NGO.
But, like I said, I think it's broad enough that it's possible that somebody can make a case like that if resources exist someday. The other possibility, which you're sort of alluding here to, is that the statute can be amended, right? And it's conceivable that additional crimes could be added, particularly in this review conference in 2009, if there's enough political support in the world to expand the list of crimes. But so far, states are already giving a lot of authority to the Supreme Court, and so they want to.
Mr. Butler, you stated that the Bush administration's position for not joining the ICC was that it might compromise our sovereignty.
That's one of the reasons.
What are the other reasons what are their official positions?
Well, let's see. I have someplace in here.
Well, what we're looking for, one of the objections was that it was not compatible with the United States Constitution, that American citizens had trial by jury and sentence. We have a different legal system than what happens in European countries. So one of the objections that the administration raised is that basically we may have to amend our Constitution to be able to comply with some of the procedures that were instituted in the ICC. And I think France actually amended the Constitution so that it can join the ICC.
Okay, I have the quote here. When the Bush administration withdrew the signature to the treaty on May 6, 2002, Mark Grossman, the Undersecretary for Political Affairs, said, "We believe the ICC undermines the role of the United Nations Security Council in maintaining international peace and security. We believe in checks and balances. The Rome Statute creates a prosecutorial system that is an unchecked power. We believe that in order to be bound by a treaty, a state must be a party to that treaty. The ICC asserts jurisdiction over citizens of states that have not ratified the treaty. This threatens U.S. sovereignty. We believe the ICC is built on a flawed foundation. These flaws leave it open to exploitation and politically motivated motivated prosecutions. Those were the reasons that are given, and those I think are what's been repeated by Bush, that he believes that it's not a good system, that he believes there aren't checks and balances, and he believes that it violates international law to hold individuals who are not nationals of states party to the treaty responsible. But like I said in my talk, the only way that can happen is if it happens on the territory of a state party or by Security Council referral. This doesn't undermine the Security Council's authority for peace and security. In fact, there's a specific provision that allows deferrals of prosecution if the Security Council wants it. There are checks and balances. For the prosecutor, and this isn't something that Mike mentioned, he mentioned that the prosecutor can initiate a case on his or her own initiative. However, once the prosecutor decides he or she wants to go forward with the investigation, they need to seek approval from a 3-judge panel of the court to proceed. There are checks and balances, and in fact, if someone believes either the judges or the prosecutors are acting in a politically motivated manner, they can be removed from office on a vote from the Assembly of State Parties. So there are checks and balances. This doesn't threaten U.S. Sovereignty. It's not a violation of treaty law, and this doesn't threaten the Security Council's role in peace and security. Those are the reasons that the administration has given. I disagree with that.
There's also been a lot of talk in the Pentagon about the possibility of a politically motivated trial against the United States, because the United States sends a lot of troops around the world. Frankly, I don't think there's a lot of merit to that. I mean, the dumbest thing that these judges and prosecutors could do would be to go off on some political crusade that would, in effect, destroy the legitimacy of the ICC, right? I mean, in other words, to prosecute something on trucked up charges that didn't really exist, just to target the United States, to try to humiliate the United States, right? And so I don't see any incentive or reason, for the court to actually do that. These constitutional issues are interesting also that you raised, but I don't know if you have time.
But anyway.
Well, wait. I want to talk about briefly the constitutional issues. The International Criminal Court Treaty gives greater procedural protections to the accused than the U.S. Constitution. Greater procedural protections to the accused than the U.S. Constitution. The one thing that the ICC doesn't have that the Constitution guarantees most U.S. citizens is there is no right to a jury trial. Instead, you're tried by a 3-judge panel. Now, in the United States, I'm a lawyer. I love the jury system because sometimes you can get something over on the jurors. And I think you've seen that happen a lot. You've seen a lot of criminal prosecutions being overturned based on DNA evidence, showing that a jury system, you can fool the jurors. I don't think it's such a bad thing that you don't have a jury system, but other than that, we have greater procedural protections. Second, the U.S. military, for military charges, is typically not permitted constitutionally to have a jury trial. Statutorily, there is a right to a jury trial. It does not violate the U.S. Constitution to try someone in the military without giving them a jury trial. Most of the things that are alleged here are things that you would be trying someone in the military for. Crimes against humanity committed on a widespread scale based on an organizational policy, or war crimes or genocide. Typically that's going to be the military. So there is no violation of the U.S. Constitution by the International Criminal Court. Sorry, I had to get that in.
It's okay. I just want a great question. Can you have a quick question? We have a quick answer. If you have more questions, feel free. This is the opportunity for you to be in contact with the speaker so that you can be in contact with them for the next, I don't know how long you want to be in contact with them.
In fact, I brought a sign-up list if any of you want to get more information.
We have a very quick question. So the way it is right now, the U.S. is not part of the SEC or not supporting the SEC. So let's say if an individual, American citizen or American individual, referred by the Security Council to be tried by SEC, and if the U.S. is, refused to give up that person, that individual, what do you see that's going to happen?
Well, it
if
can't
that
happen
happens?
because the U.S. could veto the resolution. Right? So
Oh,
the
okay.
Security Council can't ask for anything that the U.S. objects to. Now, I mean, an American soldier, might commit a crime in the in Colombia. If we had military advisors in Colombia and a U.S. soldier, assassinated a prisoner or something, the ICC could conceivably take jurisdiction over that. And that's the scenario that the Pentagon and the State Department have been paranoid about. And they've tried to force governments like Colombia to sign these agreements, promising that they wouldn't surrender the U.S. personnel to the ICC, that instead they would transfer them to the U.S. But in any case, right, the ICC judges and prosecutor would ask, well, first of all, is there a national court that's willing to prosecute? And if the U.S. Military justice system is going to look at the case, then presumably the ICC would be done.
In fact, the ICC is required to notify nations that would normally have jurisdiction before it takes a case. So when it's conducting an investigation, in Mike's example, an American who allegedly commits some type of crime within the jurisdiction of the court in Colombia, Colombia says, we want the ICC to try it. The ICC is required to give notice to the United States and give them an opportunity to first conduct the prosecution.
I would like, on behalf of VPS, I'd like to thank you, two speakers here, for taking your time out. Wonderful Saturday, continue to speak to us. I hope that all of you learn a lot.